to present this motion on the urgent need to investigate the act of negligence in the handling of the Process and Industrial Development Limited transaction by the Ministry of Justice and the Ministry of Petroleum Resources, respectively. Mr. Speaker, I would like to invoke under 8 Rule 4 and other relevant sections for us to suspend our regular rules to enable me take this motion. I so move. Thank you. Rule of Owan Federal Constituency in Edo State. Motion on the urgent need to investigate the act of negligence in the handling of the Process and Industrial Development Limited transaction by the Ministry of Justice and the Ministry of Petroleum Resources, respectively. The House notes that the recent judgment debt of $9.6 billion with daily interest accruing by a commercial court in the United Kingdom against Nigeria in a matter between Process and Industrial Development Limited leaves a very sour taste in the mouth.
Honorable colleagues, this is a very, very important motion of urgent public importance that Professor Ihonvbere is moving. I would plead that we all be attentive to listen to his motion. It's on the front burner in Nigeria today, and I think we should pay attention. Thank you. Please take your seat.
Only $45 billion and a sovereign debt profile of over $80 billion. This judgment debt is not only punitive but would devastatingly affect the Nigerian economy. Aware of the fact that Nigeria has a penchant for disregarding the sanctity of contracts and terms of agreement, coupled with the failure of Nigeria's representatives in most cases to carefully or diligently scrutinize agreements they sign, knowing that the consequences will affect past and future generations. Aware also that Nigeria had entered into a gas supply and processing agreement with the P&ID Limited in January 2010 through the Ministry of Petroleum Resources, with the understanding that Nigeria will supply natural gas, wet gas, at no cost through a government pipeline to P&ID's production facility, while P&ID in return will construct and operate the facility, process the wet gas, and return to the government of Nigeria lean gas for generation of power at no cost also. Further aware that 2 years down the road, P&ID had not built any gas plant to which Nigeria could supply wet gas processing, signifying in the first place that the move to arbitration was opportunistic and grossly self-serving, cognizant of the fact that the matter went before an arbitration tribunal under the rules of the Nigerian Arbitration and Conciliation Act 2004, with London, England as place of arbitration, and affirming its jurisdiction in the matter, the tribunal began hearing to determine whether or not there were regulatory predatory breach of contract. At this point, there was an attempt by the Ministry of Petroleum Resources to reach a settlement agreement with P&ID Limited to the tune of $850 million.
Honorable members, please resume your seat. This is a very important motion that we are taking. The speaker should not be distracted, please. Honorable Koko, Honorable Kalu, please resume your seats.
All right, I go on, Mr. Speaker. Alarmed that the agreement was somewhat shrouded in secrecy and as such apparently dubiously procured, as those who ought to know about its existence did not, and more importantly, the relevant laws in Nigeria for the transaction to be consummated was not applied, Part 4 of the Bureau of Public Procurement Act 2007, which deals with the fundamental principles of procurement. Further alarmed that it took the new government more than 4 months to respond to the vital arbitration judgment of about $6 billion, with a ridiculous excuse that there had been a change of administration in Nigeria, and the ministers, including the Attorney General, had only just been appointed, thus asking for an extension of time to act on the outcome of the arbitration tribunal. Alarmed that rather than engage P&ID in the matter before the tribunal with robust legal arguments and interpretations, Nigeria was busy shopping for a favorite forum to plead a case in a court in Lagos, Nigeria. Worried at the lack of diligent prosecution of cases in which Nigeria is involved by those whose duty it is to do so, is due to a tendency to either politicize everything or focus more on personal interests or failure on the part of all parties involved. Observe that Judge Butcher J., the judge in the matter, in his August 16, 2019 ruling, made heavy weather out of the several acts of omission on the part of Nigerian authorities, especially when he noted, and I quote, "The Federal Republic of Nigeria had remedies for many procedural unfairness, but did not utilize them," unquote. Nigeria could have objected to the procedural order number 12 or questioned the final award. In the words of the judge, quote, "It did neither, and the time for doing so is long past," unquote. These are serious indictments of the competence and gross negligence displayed by our representatives, agents, arbitrators in this matter. Further observe that this embarrassing judgment exposes
Honorable Mike, please resume your seat.
Exposes a deep decay in our governance and leadership structure with far-reaching implications for the credibility of the country's capacity to handle business and legal cases. Resolves to, 1, mandate the House committees on justice and petroleum resources and other related committees to, as a matter of urgency, invite both ministers involved and other officials of the ministries saddled with the responsibility to negotiate the agreement with P&ID and the prosecution of the matter before the tribunal to give situational report on the matter and explain the lapse in judgment of time and due diligence in the mishandling of the case with a view to finding lasting solutions to the avalanche of extant and future cases. Recommend appropriate sanctions where necessary without fear or favor or preference for status in line with Order 14 of the standing rules of this House. Initiate a process for reviewing all agreements and treaties signed by Nigeria through the appropriate committees to create opportunities to discover anomalies and avoid a repeat in the future. I so move, Mr. Speaker. Investigation. So I suspect that the appropriate will be for us to refer it to the relevant committee. But if we want a debate on it, I am prepared, fully prepared. Many of us in this chamber know the state of the Nigerian economy. Some of us here have suffered greatly. Some of us here are under pressure daily from our constituents. Some of us here have tried to even get some facility from banks to run businesses without success. The issue we are raising in this motion, we are not looking at the issue of jurisdiction, whether the case ought to have been in London or in Nigeria. We are not looking at the question of attachment, whether the court that ruled actually had the authority to so do. We are not looking at whether the P&ID breached the contract in the first place because it did not use any gas facility to which Nigeria would supply wet gas, so that going to court was opportunistic. We are not looking also at whether Nigeria surrendered its immunity in this case Neither are we looking at whether the issue of sovereignty, national sovereignty that is involved, and to what extent a judgment could be given in London, and a motion also moved that there could be an attachment of the properties or assets belonging to the country. What we are looking at actually is how did this happen? Who was involved in this business that has led to this quagmire? Adeni wrote an article recently and said that nobody in the hierarchy of the Yar'Adua government knew anything about these contracts with P and ID. We also have seen an article recently classifying the character involved in this business as a shady character who was involved in running from one ministry, one government to the other, entering into deals that he will not execute in order to lay claims of breach. Mr. Speaker, our country is in trouble. $9 billion is almost 35 trillion naira. We know what that can do for education, what it can do for security, what it can do for health services. Our rural areas all across the country are in their need of basic needs, but we can't provide them. We say there is no money. But now a court has hung $9 billion, almost 35 trillion naira, on our necks. Our call is to investigate this, to find out who were the characters who went into this deal. Did they carry out due diligence? And the prosecution, Mr. Speaker, the Ministry of Justice, how could a permanent secretary inform a court that had ruled against the country that they could not respond or do anything because ministers had not been appointed? It's an insult to the integrity of the officials in that particular ministry. And the permanent secretary involved with that, we need to investigate how come, what is going on in the ministry. Mr. Speaker, there are hundreds of other agreements like this. And in our standing orders, there is provision that these agreements should be brought to the National Assembly to be vetted. This is never done until when the consequences. We know also there are other hanging agreements with Mambila. There are some with global infrastructure where we breached agreements or we refuse to comply with the terms of an agreement, and at the end of the day, we are running from pillar to post, hiring lawyers abroad, paying them heavily just to see if we can survive a problem we have created with our own hands. Mr. Speaker, finally, unless we investigate this matter deeply, we find out the characters and actors and the institution involved, we try to save the name of our country. We don't even have the foreign reserves enough to pay off this kind of debt at once. And when they move against us, it will be very, very embarrassing. Interest is accruing daily on that $9.6 billion. Mr. Speaker, this is an urgent matter, a serious matter. I think the House should take it as it is. Thank you so much, Mr. Speaker.